So we're going to do this as a little bit of a kind of a conversation in a way, in the sense that we are going to go in an order. But if you, all of us up here, if you have questions, just feel free, raise your hand and spur of the moment ask. Everyone here is comfortable with that. And you all have bios of these folks, but I'd like each one of our panelists, as they begin, to tell a little bit about themselves and what they do, what their focus is, so that you can get some sense of not only why they're here, but how they might be a resource to you in the future. And so I'd like to start with Colin.
Grab this one?
Yeah, anyone.
All right, thank you so much. And I just want to echo what Maurice said as I talk up here. Feel free to interrupt. Feel free to ask any questions. It's sort of what I think about and talk about all day long, so I'm excited to get your thoughts on it as well. I'm a staff attorney at the Criminal Justice Policy Program at Harvard Law School. And there, the bulk of my work is on bail reform in various jurisdictions across the United States. This falls under kind of a bigger tent for a project that we have there that's on the criminalization of poverty. A lot of our work is also with criminal justice debt and fees and fines. So I'm going to talk a little bit today about the pretrial system as it exists, or pretrial systems as they exist across the country. And a little bit on the nature of contemporary pretrial reforms, and then some pitfalls with those reforms, some challenges that we can see on the road ahead. So in the United States, if you're accused of a crime, you'll find yourself typically in one of three dispositions as you're awaiting trial. The first would be that you're released on your recognizance. Release on recognizance basically means that you promise to the court that you will return, and then you're free and you're able to go home. The second form is release on conditions. So this is that you are released from jail and you are able to go home, provided that you fulfill certain conditions. Money bail is the most popular of those in this country, but that's not the only one. In addition to that, there are conditions such as electronic monitoring, stay-away orders. For example, in a domestic violence situation, that it could be that you have to stay away from a certain person or a certain area, or plenty of other things, including mental health treatment, drug treatment, staying employed, things like that. And then the last disposition is incarceration without the possibility of release. And typically, in most areas, this last disposition is rare. That it's something that a judge can only impose. Typically, if someone has been charged with certain crimes and through a separate hearing that has certain procedural protections. In effect, what happens in this country, though, is that most people who are incarcerated pretrial are incarcerated because they can't afford money bail, that they've been ordered to be released on a condition of money bail, and they can't afford the bond amount that's been imposed. The United States is unique. We're unique. There's only one other country in the world that has a for-profit bail system. And what this means is that, let's say, I leave here, I'm accused of a crime, I get a $5,000 bail imposed on me. I can't afford the $5,000. It would mean that a bail bond agent I could pay, or more typically, a family member or someone else could pay 10% of that bond amount. And if they could pay that 10% of that bond amount to a bail bond agent, then they could secure my release. The difference between this and posting that $5,000 with the court is that I will never see, in this case, that $500 again. That money just goes straight to the bond agent. That never gets returned. If I get acquitted, if my case is dismissed, it doesn't matter. I still have to pay that money no matter what. On its face, we can see the problem with this money bond system is that it discriminates based on wealth. It discriminates based on wealth. That it's obvious that if you are wealthy, it doesn't matter what bond amount is imposed, you can pay it and you can leave. If you're not wealthy, then you either are faced with potentially an onerous situation in which your family has sacrificed money that they're never going to get back, or that you're just stuck in jail pre-trial. And this has resulted in a system in which the United States has a staggering pretrial incarceration rate, and a much higher incarceration rate than we ever had historically or that other nations across the world have. We have 4% of the world's population, and we have 20% of the world's pretrial incarcerated population. And those are just the problems on its face. There are deeper problems as well. Empirical studies have shown that Hispanic and Black defendants who are similarly situated to white defendants are more likely to have bail imposed that they cannot afford and therefore be incarcerated pretrial. And other studies have shown that this money bond system has a negative effect on public safety, that it's something that even a few days of a stay in jail makes someone more likely to commit a crime in the future after they're released. And some of this, makes sense in a way, that it's something that if you're incarcerated pre-trial, even for a brief time, you miss your next shift at work. You're not able to show up to your job, you lose your job. If you lose your job, then you get a chance at losing your housing. If you lose your and all during this time, you might also lose custody of your children. Even if you are able to secure release, it could be that the only way your release was secured was because family members put up collateral, put up their homes, put up their cars, and things like that. The other big problem with it is that it's illegal. So I won't go into it too much. Maybe Charisse touched on it when she talked yesterday. But it's, detaining people because they can't afford to pay bail is unconstitutional. And it's something that there's litigation across the country that's coming out that are challenging these practices. So what can be done? And what can be done specifically, because this is a conference on rural justice, that it's something, a lot of the focus has been on statewide reforms and legislation and constitutional amendments, but there's a lot that can also be done at the local level. And I should say that the first part here for bail reform is, and I think that this is common among all advocates here, is that the number one goal is to reduce pretrial incarceration rates. And an important thing that I'd like to emphasize here again is that this isn't radical. The situation that we're already in is the radical situation. That the United States is an outlier, not just among nations in the world for how many people we incarcerate pretrial. We're an outlier historically in terms of compared to what we have done. In the last 20 years, we've almost doubled our jail populations, and all of that net growth can be attributed to increases in pretrial incarceration. So releasing more people pretrial is bringing us much closer to our historical norm and international norms. The first way that this can happen is just that judges can order more people to be released. We would have nationwide bail reform tomorrow if judges didn't impose bail that people couldn't afford. Just to call someone out, I haven't met you yet, but Allison Sherry. Allison has a great article on a judge in Colorado who did just that. He looked at the litigation that was occurring in Harris County and decided that the practices that were going on in his court weren't constitutional, and he decided to stop imposing unaffordable money bail. If we look to Chicago, the chief judge in Cook County created an administrative order that said that the judges there couldn't impose bail that people couldn't afford, that they had to make a determination before setting bail that it was a bail amount that someone could afford. Beyond judges, that it's district attorneys. Larry Krasner was here yesterday. His office has adopted policies that they won't be asking for money bail in certain situations. And then beyond that, it's also that a lot of these practices are not codified into law. A lot of these pretrial practices are just the cultural norms within a court, or potentially rules or guidelines that are developed oftentimes with committees with judges and prosecutors and defense attorneys. And sometimes these committees can kind of very quietly and effectively achieve some really substantial reform. So, one that we're highlighting in a report that we'll be publishing later this summer is Mesa County, Colorado, decided to stop imposing fees for pretrial services. And it wasn't because the ACLU sued them or something like that. It was because the DA's office, the judge, and the public defender's office all decided that this was a public good and it shouldn't be something that is achieved by imposing these fees on people, and they very quietly and effectively, until I made a big announcement right now, but very quietly and effectively did that, and that I think that's one of the there's a lot of emphasis when we're talking about bail reform in this country on big legislative action, but there are a lot of things that can be done either by judges, by prosecutors, by sheriff's offices as well. How am I on time?
You're fine.
Okay. So I'd like to just highlight two means through which these reforms are being achieved, and then some concerns that have been raised about these. The first one is through the expansion of pretrial services. So oftentimes what happens in order to, and I think a big push for this is to encourage judges to be comfortable with releasing more people, that it's something, currently there's sort of a binary situation that judges have that is either release or detain. And pretrial services, we've seen it across various jurisdictions, have been expanding what they've been offering in terms of things that judges can order for conditional release, to include things like mental health treatment, electronic monitoring, drug testing, and the like. And a big concern that we have with that is that onerous conditions of release have been shown to have first of all, they're burdensome for the person for whom it's being imposed, who is only accused of a crime and is not convicted of a crime, but then they also have a negative effect on public safety at large. So there have been many, many empirical studies in the probation context that show that imposing too many conditions kind of sets people up to fail, and people who've had excessive conditions imposed are more likely to commit criminal activity in the future, as opposed to people with fewer conditions who are better able to avoid doing that. So it's something that we're very concerned that's just going to get repeated in the pretrial context, and that people have too many conditions imposed, and conditions that aren't related to the situation they're in, and then also that don't respect that the person who is on pretrial release has not yet been convicted of a crime, and in that way has a greater liberty interest. And the other big concern that we have that I briefly pointed to was fees for pretrial services. That fees, this is the standard paradigm right now, is that you're charged for pretrial services. So one example would be that you could be charged $26 a day for electronic monitoring. You're charged $26 a day for electronic monitoring. That means you're charged $900 a month. Let's say that takes 10 months before your case is disposed, and in many jurisdictions that would be pretty lucky if it was only 10 months. That's $9,000 that you owe. That's $9,000 that you're never getting back. You're probably in that situation not able to afford it in the first place, so you and your family are then on an installment plan that you're stuck paying that. If the problem of money bail is that it discriminates based on wealth and race and imposes these undue burdens, then replacing it with a system of something like electronic monitoring where you're still stuck with all these fees, that doesn't seem like real reform to us. So it's something to be really cautious about going forward.
Let me ask you a question in relation to that. So someone gets their case adjudicated, and it's 10 months later, and you owe $9,000 or whatever, and you get probation. Is a condition of that payment of this? And if you don't pay it by a certain time, can you get revoked?
That's, I'm
just seeing what a cycle this can be.
I mean,
where, and my real job is with the National Registry of Exonerations, and I see occasionally cases that come out of Texas where people get a deferred adjudication, and then they keep getting revoked to the point where at some point they go to prison, and sometimes it's because they haven't made their payments, or they didn't drop, or they don't have a cell phone, so all these kind of conditions, and I'm wondering if this is something that can basically lead to the same thing. You get stuck with a bill, and you agree to plead guilty because you're going to get probation, and you can keep your job, but
yeah, and I mean the example there, is imagine this, that you get this $9,000 debt, you're then on probation. The condition of probation is that you pay those fees, and then you can get revoked. The other is just that, in some jurisdictions, not paying that criminal justice debt can result in something like revocation of your driver's license. So because you're not able to pay that $9,000 for that electronic monitoring, you no longer have a driver's license. You could be in a place, especially that, unlike New York City, that doesn't have public transit, right, where you need a car to do anything. And then you're driving, because you weren't able to pay that debt, your license is revoked, then you're arrested, and now the cycle continues all over again, and now you've got the crime of driving without a license. So that is a huge concern, is that these things compound, and that if we're going to be getting away from a money bill system that compounds these problems for people, that we really don't want to introduce a new system that does the exact same thing.
I could see someone making a judgment of a decision like, well, I'd rather wait it out in jail because it doesn't cost me anything. I might lose my job, or but rather than saddling my family with this enormous, it's one of those, the lesser of two evils, maybe.
And the other side to that, too, at least in respect to electronic monitoring, is that if you're in jail, that time is counting towards whatever your eventual sentence is, right? That it's something like those days that you're serving. If you're on electronic monitoring and you're on house arrest and at home and can't leave, then not only are you going to get that, let's say, $9,000, you also couldn't leave your home during that entire time, and none of that counts towards whatever your eventual sentence is. So I think all of these things are important considerations.
So, Colin, are you saying that as part of the reform, that it should not include more pre-trial services?
So one of the things, so we have an article coming out that's addressing just this, and it's on how pretrial services should function. And in that, we outline a number of principles. One of the big ones is that pretrial services should be aimed at supporting rather than supervising. And one of the things here is, a lot of, the knee-jerk reaction for a lot of jurisdictions is to bring whatever you're doing in probation into pretrial when you're doing pretrial services. And there's a lot that can be done in pretrial services that isn't working that way. What we found out is one of the most effective pretrial services is phone and text reminders. That it's something that just telling people that they have upcoming court dates is very helpful at having people show up to court. In some jurisdictions, it's increased appearance rates by up to 37%. One of the other big problems with pretrial services is that not enough has been studied on them, that there's not a lot of evidence-based practices going on, that we really don't know how effective different services are. One thing that seems to be the case is that giving people options for services is more helpful than imposing services. So, for example, one thing for mental health treatment. Giving people the option to receive mental health treatment results in better case outcomes than just imposing it and making it a condition. And then, some other concerns that we have are, that the principle of parsimony should apply. That it's something that, let's say that, we're in New York. Let's say you're accused of turnstile jumping, right? And that's the charge that you're facing. It seems kind of ridiculous in that situation that your conditions of release could be things like alcohol and drug testing, and that your release status is revoked because you had a drink or something like that. It's unrelated to the charge that you're facing, and what it in effect becomes is a form of social control just because you've been accused of a crime. So we think that, I do think that we can have pretrial services that help. I think that pretrial services can be expanded. They can offer things, but it should be, the Chicago Community Bail Fund has a report that's titled "Punishment is Not a Service," and it's looking at different people who are on pretrial release there and the conditions that have been imposed on them. And I think that's an important way to look at it. And I think that to the extent that there can be services that help with case outcomes but aren't unduly intrusive, that's a way that jurisdictions can go. Sorry, I just missed that.
Do you know any studies about Native American disparities?
Off the top of my head, I don't, but I can certainly look into our research to see.
Let's wait for questions until after.
Actually, why don't we just leave the microphone out there and they can pass it among themselves? It's because you just don't want to get up.
Well, I don't need to hog over all the time too. I can pass it on for now.
And we can have questions. Right next to me is Tina Luongo from the Legal Aid Society. We haven't had much of a perspective at all from the defense community, and so I think that she can provide a unique view here. And
Setting the bar high.
yeah, tell us a little bit about what you do.
Sure. Hi, everybody. Good morning. I'm Tina Luongo. I'm the chief defender for Legal Aid Society, which represents here in New York City about 200,000 people who are arrested and prosecuted in our criminal court systems in all 5 of our counties. But New York City and New York State is complicated. New York City also has other defender organizations because we are independent. Here in New York City, we're independent nonprofits that contract and are paid by the county to provide services. So you might have heard of organizations such as Bronx Defenders, Brooklyn Defender Services, New York County Defender Services, Neighborhood Defender Services of Harlem. These are all public defenders here in New York City. But New York State is very complicated. As I said, we're a county-based system. I was just talking to somebody from Utah. And when you have a county-based system, what that basically means is every county funds public defense in a different way, based on how much revenue the county has. So in New York State, there's 68 separate counties. So here in New York City, we might be and are, in fact, historically been funded better than, let's say, Chattahoochee. And in fact, in New York State, in many counties, up until last year when our governor signed the Justice Equality Act, and as a result of a lawsuit about high caseloads and no funding, some counties, when you are arrested in the middle of the night, and you are, and it might be on a low-level offense, driving without a license, for instance, is a big one upstate because it is rural when you think about many upstate communities. Despite you're sitting in New York City, not every place looks like this and not every place has a subway. You're brought in the middle of the night to someone, to a judge, and I will do that in quotes only because that judge in many counties is not even an attorney and was only trained to be a judge on a part-time basis. And you're brought there by the sheriff, and there's has historically not been a district attorney at present, there isn't, and it may actually be not in a courtroom, could be in the garage of the judge. And for a really long time, you didn't have an attorney with you at what we call first appearance. So that's a different situation here than in New York City. In New York City, when you are arrested, you are brought to a courthouse, you're brought to a precinct, and you are booked at the precinct, and eventually transported by police to the courts that operate up until from 8 o'clock in the morning till 1 a.m., and there's a court, and there's a judge, and there's a prosecutor, and there's a district attorney. And you see a judge, thanks to a lawsuit Legal Aid Society brought many, many years ago, within 24 hours of your arrest. So why is that important when we look at what Colin was talking about, which is that decision-making between release on your own recognizance, release with conditions, or in some cases remanded? Although in New York State we have an interesting law that doesn't consider dangerousness, only considers risk. We could talk about that later. But the most important part in that moment of when decisions are being made that will ultimately, that one decision, and I started my career as a public defender right here in New York County in 2002, and I will tell you that the bail application in front of the judge lasted only 5 minutes, if you think about that. And it usually went like this. My client is brought out. I'm standing there already. Prosecutor's there, judge is there. And first thing, if you were charged with a misdemeanor, let's go with a turnstile jump. The first thing out of the judge's mouth, not what happened here, counselor, tell me about your client. The first question, and still is today, from a New York City judge is, prosecutor, do we have a disposition? So the first thing on a misdemeanor is, do you got a deal? Are you going to plea out? Not what happened, not tell me about your client. Do we got a deal? Now, I've just met my client in the back of the courthouses and had what I would hope to be a conversation with my client for about a half hour at best. But that's all I know. I haven't been able to send out an investigator. It's in the middle of the night. I don't even know. Whatever the client told me is privileged, but I can't act on any of the information. But do we have a deal? And in front of the prosecutor, in front of the judge, is my client's criminal history and an assessment of whether my client should be released to the community based on community ties. Are they going to run if they're released? Are they a flight risk? You might imagine in that moment, my client may be thinking, if I have a criminal history, I should take that deal right now, even if, by the way, I didn't jump the turnstile. Because if not, the second question is, I'll hear you on bail. So, do I have a deal? And I say, Your Honor, we do not. And then the judge turns to the prosecutor and says, Counsel, I'll hear you on bail. And now the DA is going to, based on my client's history, ask for bail. That's the two questions. Nobody's still not talking about, tell me about the case, tell me about your client. It's only after there is an announcement of whether the prosecutor will ask for bail or release my client, ROR, on their own recognizance, do we have an opportunity to talk about the facts and my client. Now, in New York City, the concern to be held at Rikers is a big factor for people. And by the way, I'm going to fair to say, in every decision, probably in every jurisdiction, a client is factoring in, do I go in? And what does that mean? Am I going to lose my job? Where's my kids right now? Like, what atrocities am I going to face if I'm held pre-trial, and how long? And right, so the impetus to plea is right there. So that's New York City. Now remove that entire process. Remove the fact that there is a public defender or a lawyer fighting for the client to say, no, you shouldn't, don't listen to the prosecutor on the bail request. My client should be home, and here's why. I've checked my client's community ties. By the way, my client denies the allegation. Really? Right? Very important to say. Right? All the things you say as a lawyer to advocate for your client as to why they should go home. Upstate didn't have that for decades. That's the hidden crisis when you think about rural justice. Those things went unchecked for decades. And that role of the public defender to insert ourselves to push back against that system is critical. And so we do that at Legal Aid Society. We do that. I'm the president of the Chief Defender Association for the state of New York. And public defenders are doing that routinely, and we're routinely doing that across the country. And the voice of those of us who are representing clients in not only the conversation about bail reform, but all the other criminal justice reforms are critical. But the real question, and something for you all to ponder as you cover stories or want to talk about client experiences, is how did they get there in the first place? So this notion of really looking at the criminal legal system, not from the point of the doors of the criminal justice system, but the systems that are driving people to the criminal injustice system, as many know it, are the things we should be tackling if we want to get to the heart of the problem. So the other way to do bail reform and decarcerate is to look at policing practices. and the system of that. Because what drives people to the criminal system is not criminality, it's poverty. It's all those broken systems. It's the why, asking the why the person is where they are in their moment, looking at communities that are getting policed, black and brown communities, at far higher rates. Those of you may know in New York City, we called that policing for decades broken windows. It still exists today. It's the question of, why are you arresting somebody for turnstile jumping? Oh, because they're homeless and they can't get in New York City, where you have an incredibly great public transportation system. It costs $2.75, and people don't have that money to get around. So let's look at that. Let's look at that system. Let's look at how many lack of supportive housing beds there are. Let's look at reentry, because when somebody comes back from state prison in New York City, they're given a Metro card and dropped off at the Bellevue Emergency Men's Shelter with no housing plan. And many of them can't go back to the city-sponsored housing, New York City Housing Authority, because they might actually now violate the potential of a lease because of the convictions. So they're barred from moving back with their family. So that now take that and move that rural. So chief defenders upstate are routinely talking about the crisis of, you have a license suspension, now you need to get to court. You have a license suspension. Your license is suspended. You can't drive. How are you getting to court? There's no bus. There's no train. You have to drive. You get picked up again, right? So the question of, well, can't you do something else about why the license is suspended in the first place? Why, right? And so when you're looking at bail or any criminal justice issue, starting at the source of where that started, the fact that, we don't recognize the need for the mental health treatment until it's a crisis, until someone has done something in the community or is now locked up and can't get back home, that's incredibly important. And so the driver to the door of the courthouse is important. And then looking at it from the judicial perspective, right? So judges, Colin's right, judges we say it all the time, could close Rikers tomorrow. We have a 10-year plan in New York City. Actually, we can do it probably tomorrow. Judges just have to be brave enough. It's not closing tomorrow because there is that, I'm not putting my neck on the line. Here in New York City, we've done an enormous amount of work around reforming our practices, not necessarily our laws from Albany, but our practices here in New York City, to actually reduce the number of people who are actually being arrested, and if arrested, prosecuted for low-level offenses. Right, so our district attorneys came together with all the public defenders and all of the stakeholders, and we said, this is ridiculous. Nobody should be sitting in on Rikers on a misdemeanor anymore. This is crazy. And we've done it in several ways. We have charitable bail funds, which are nonprofits, not generated by the for-profit industry, that are allowed to bail out people $2,000 or less on a misdemeanor. And that's been very effective. And what's very effective about that is not only does somebody get to go home, but the data that's been used. So there's this idea that the reason why you have family members put up bail is because nobody will skip on their family member. Except in charitable bail situations, it's not a family member, it's a charity. And the return rates are as good as anywhere. And in fact, and more importantly, is as good as ROR. So really the point to make about this, and the charitable bail funds will say this, is their data is really great to show that actually you don't need any conditions nor money to get somebody to come back to court. It's a Metro card or a way to get to court and a reminder, right? And so we've done a really great job of making sure that people aren't being held in just on low-level misdemeanors, even if we can't push the cops to not make the arrest in the first place. That's still happening. That's a reform that still has to happen. But, we're seeing less. But that means that judges now are analyzing the more serious of issues. Misdemeanor assaults, driving while intoxicated, and felonies. And there you have to have judges willing to want to release people. And they should, because the statistics show you can have somebody safely in the community and they can come back to court, and it's done in other jurisdictions. So when we're looking at judges, data matters. So 538, that's their policy and data wonky shop. They did the big thing got it wrong, on the presidential election, right? Like, we were all banking, that somehow didn't happen, but 538 does research based on data. They utilized our data to show which judges in New York City release people and which don't, and what is the rate of release. Why is that important? I want to believe, as a person who sort of wants to believe in the good of humanity, that judges aren't just doing it from a bad place, that they're doing it because they're part of a system that's a rote, and that's all they know. They are in this sort of cultural hamster wheel, right, where they're making decisions on the fly very quickly with very little information. Their implicit bias to cover their back, and their implicit bias on race and poverty and gender identity and all the rest is all playing in. And the faster you do it, the more that happens, right? The more implicit bias, like slowing down, stops implicit bias. So judges are making these decisions. They're also trained by other judges who are doing the same thing. So nobody's saying, hey, look at the data. Did you know that you were setting this much bail for people when you didn't need to have to? Did you know how many people you sent to Rikers last year? Some of the judges who, former legal aid, public defenders who be on the bench, looked at this data and were aghast. And were like, I didn't realize in the moment. So data, when you're doing your stories, when you're covering this issue, look at it from a data perspective too, because the system is not operating as it should with utilizing data to make critical issues. But the public is unaware too. And the public plays a role in all the work that we do. And we can talk more about that. So I can tithe my time over. And we can, if you want to, we could talk more about the role you play in educating the public, because it's critical to the discussion.
Let me just ask you a question that you touched on, and that is do we have a deal? There's a coercive effect that bail, and also the realization that there's a trial tax, that it's inevitable. And Harris County over the last few years has had this phenomena where the crime lab there tested all cases, whether people pled out or not. And they were routinely sending the results via email to the district attorney's office. And it was going into what, in effect, was a dead letter file. And someone discovered this after several years, and what they found were about 400 to 500 cases where people had pled guilty because that was in their initial appearance, and this is a one-day sale, and they had to make a judgment, and they pled guilty, and then ultimately the lab tests were done, and there was no controlled substance because it was based on a faulty field test. Now, maybe some of these people thought they had drugs, but there were ProPublica actually did a tremendous piece on this, and all about the fallibility of field tests, and things like cat litter was testing positive for cocaine, and different things, and people were losing their jobs, the same sorts of situation where you're going to face a bail. So a lot of these were people who had priors, and so you come into the repeat offender situation where the one-day sale is 30 days, or we'll knock it to a misdemeanor and it's 30 days, or you can sit here and we'll take you to trial on a felony 6, 8, 9, 12 months from now, and maybe you'll get convicted of a felony, and as a repeat offender, it's 25 to life. So that's a no-brainer. But bail plays a part in that, too.
We see it a lot. Also, the fact we have a case here, unfortunately, in New York that actually didn't require, sort of remove the responsibility of the prosecutor to actually then have the drug testing, the full drug testing done before the plea. And what we see there is, if you have a co-defendant situation where someone bought the drug from someone else, the person who bought the drug is in possession, that's a misdemeanor, would take a plea immediately. The person who might be charged with a felony, that case is the person's in on bail, that case continues, and when it is finally tested, because it has to be tested for trial, right, to make beyond the reasonable doubt, and it comes back negative, that person just sat in, potentially, right, for all of those months. There was a person who a year ago took a plea. Now, the prosecutor will vacate the plea to dismiss it, but harm done, right? Person could have lost their job, could have lost their bed. So, yeah, it happens all the time, that coercion to plea. When people say people who aren't guilty don't plead guilty, it's not true. People plead guilty because they are avoiding something that's worse. And whatever that consequence is, for some, it is the fear of going in to a carceral system that is going to eat them up alive, literally and figuratively. For some people, it's the fear of not seeing their kids if they're in, or losing the job, right? Or, right, keep going. Like, it's whatever, or having, even if someone's out in the Bronx here, there was a New York Times story about the amount of delay it takes to get to trial. On a misdemeanor, the average was 3 years. Now imagine if you were out, not in, out. Every other month, you'd be coming back to court for 3 years. People have lives. We have lives. Can you imagine doing that? Like, now imagine doing that where you don't have any resources to travel or put your kids in daycare, or you're working an off-the-books job because you have to scrape money. So people are like, I'm out. I can't come back. I can't come back for 3 years. I have to go. And, by the way, I want to go on with my life. I'm going to put this behind me. So the primacy of whatever is important, whether it's coercion or in the form of carceration, or coercion because you cannot have this go on indefinitely, plays a huge role.
And it's a different balancing act. That for us, we might say, well, I don't know what I would decide, but for a lot of people, it is a different. So I'd like to turn this over to Larry and tell us a little bit about yourself and what you've been doing.
Okay, great. And is there someone? I have PowerPoint slides, so I'm not sure if someone is. Hi, I'm Larry Wein. I'm an applied mathematician. I have not spent my career looking at crime. For the last 20 years or so, I've been working in various problems in public health and public policy. A somewhat related field that I've worked a lot in is Homeland Security. So I had a handful of my policy recommendations implemented nationwide after the September 11th attacks, in particular on catastrophic biological and nuclear attacks. But the last few years I've been looking a little bit at crime. Do you have the slides there? So this is the talk I will be talking about. Could you go to the next slide, please? So the bottom part, the top part is just some of the stuff that was implemented in the Homeland Security. The bottom part is work I've done in crime. The big picture here, the goal of my research is to reduce the number of type 1 and type 2 errors with respect to incarceration. So one type of error is that there's some people out there who are extremely violent and dangerous who should be incarcerated and are not. And so I've been working on basically using technology to solve crimes, in particular ballistic imaging to solve gun crimes, and DNA matching to solve sexual assault. So I encourage you to read my CNN.com op-ed that came out a few months ago on sexual assault kits. But today I'm going to focus on the other type of error, which is that there's a number of people who are not very dangerous, who are incarcerated and really should not be. And could you go to the next slide, Pete? So the background here is that for the first time in this nation's history, the U.S. Supreme Court forced a state, in particular my home state of California, to reduce its state prison population by a lot, by 30,000 people, due to inhumane conditions and severe overcrowding. And California went ahead and did that, and they took some of the people in the state prisons and put them out on the street, and took other people and took them out of the state prison and put them in the local county jails. As a result, the county jails became overcrowded. And two of the main options that are available to reduce overcrowding in the jails, one is pretrial release that we've just spent the last half hour talking about, and the other one is something called split sentencing. So for example, someone gets could get a 6-year jail term, and instead you give them a 3-year jail term and then 3 years out on mandatory supervision. And this is available for low-level felons, and this is, so it's a bit like parole, but it's hardwired into the system up front. So what I'm doing in this research is building a mathematical model of the jail system, and one aspect that we're including is that many correctional systems in this country use risk-based tools to predict the likelihood of recidivism if you release someone, for example, during pretrial release or during the second part of your split sentence, or the likelihood that you will appear in court. And I'm guessing that someone from VEER or something talked about this yesterday. And so this is an active area of research. Some people are trying to optimize these statistical tools. Other people are trying to understand if there's racial bias within these tools. Last time I looked, there are 19 of these tools that are being used currently in this country. I'm just taking these tools as given. And next slide, please. And looking at a higher level question, which is what's the optimal risk base that is individually based on essentially the demographics but not race, and based on your criminal history, what's the optimal pretrial release and split sentencing policy? So who should get pretrial release, who shouldn't, who should get a split sentence, who shouldn't, to optimize the trade-off between public safety and jail congestion. That is to, you can go forward, that is to minimize the number of crimes committed by someone who you release, but you could have held in jail, but also to minimize the number of people who actually are in jail. Okay, you can, and we're using data from the world's largest jail system, which is the Los Angeles County jail system, and all those, this is a highly urban area, and just as we heard from New York City, but a lot of these issues that we're talking about also happen in the rural areas, and there's, as you know, many overcrowded county jails in rural areas. Okay, so I'm at Stanford Business School. I teach the core MBA class in operations management, which teaches things of how do you manage a factory like a Toyota automobile plant? How do you manage a service operation such as a McDonald's? So this involves repetitive processing over and over again. And one can view a jail system as this too, that you keep having people arriving, new people arriving. You're processing them very quickly and putting them in the system. And how do you manage this system? Okay, you can forward a number of slides. Keep going. So I'm going to skip all this stuff. Keep going. Keep going. Okay, stop there. You can't probably really see that. But in our model, there's 3 different risk levels. So each person, based on their history, is either low risk, medium risk, or high risk. And there's 3 classes of decisions we're making. One is pretrial release for felons, pretrial release for non-felons, and split sentencing, which really is only applicable for felons. And so for each of these types of decisions, we have 4 options. So we can either be really hard. For example, for pretrial release, we can be really harsh and not release anyone. Or we could release just the low-risk people, or we could release the low and medium-risk people, or we could be lenient and release all the people, including the high-risk people. So 4 times 4 times 4, we have 4 options for each of these 3 decisions. 4 times 4 times 4 is 64. So we're going to evaluate 64 decisions using computer and math and stuff like that. So the next slide has the main results. So this is on a trade-off curve. Again, we're trading off public safety and people in jail. The vertical axis is the amount of crime that's committed by people who release. The horizontal axis is the number of people in jail. So we would like to live in the lower left corner of this curve where there's very little crime on the street and there's very few people in jail. So these 64 points, one for each policy, are put here, and I group, after seeing the points, I group them into 4 curves of 16 points each. And it's probably hard to tell by the color, but it's clear the lower left curve is the curve that dominates all the other ones. That's where you want to live. Regardless of how you feel about the actual trade-off, you want to live somewhere on that curve. And that curve corresponds to offering split sentencing to everyone, even the highest risk people. So even if you haven't followed the details here, the punchline of this paper is that from a purely operational point of view, split sentencing is in a sense more effective than pretrial release. And so the next 2 slides are really the main thing I want to take away, is to try to understand why this is true. So in this paper, we introduced the concept of a risk ratio. For each of these types of decisions, pretrial release or split sentencing, we're releasing someone for a certain amount of time. And during that time, we're exposing ourselves to the risk of recidivism. This person's going to commit another crime while we could have been holding them in jail. On the other hand, if we're releasing them, we're reducing the jail population, but for a possibly different amount of time. And this part in red will be clearer on the next slide. And then we're going to define this risk. No, go back. Sorry. And we're going to define this risk ratio as the number of days that someone was released divided by the number of jail days that we've saved by releasing them. And the easiest one to think about is split sentencing. So suppose we have someone who could have got a 4-year jail term. Instead, we gave them a 3-year jail term and gave them a year of mandatory supervision. Then we're releasing them for 365 days. and we have that recidivism risk during the 365 days. On the other hand, we're saving 365 days of a jail bed. We're reducing that. So 365 divided by 365 is 1. And so the risk here is 1. Now let's go to the next slide. And so the key insight here is that for pretrial release, the numerator is going to be the time from arraignment to case disposition, so that is until you decide whether they're guilty or innocent, if we release them. But the number of jail, and that's the length of time that we have this recidivism risk. But the number of jail days that we save is the time from arraignment to case disposition had we detained them. And it turns out these two numbers are remarkably different. In fact, Maurice, gave us an example of that 10 minutes ago, and you probably can't see those numbers, but the ratio for non-felons is 16, and the ratio for felons is 3.6, relative to the risk ratio for split sentencing, which was 1. So these, in a sense, are much, much riskier trade-offs, the pretrial release. And so the big question is, why is this true? And people have already alluded to this, really gave the answer to this before, is that if you're on pretrial release, you're less apt to plea bargain. So almost all, very few things go to trial here. Most of it is plead out. And when you're on pretrial release, you still maybe have your job, you're with your family. You just hope if you delay long enough, this whole thing's going to disappear, and you're not in a big rush to plea. Whereas if you're detained, it's kind of, as Maurice called it, or one of you called it, a one-day sale. It's like you're kind of screwed, and you're pretty much going to take the first offer that's made to you. Okay, so let's carry on to the next slide. Next slide. Yeah, I'm going to skip a bunch of slides. Skip that, skip that, skip that, skip that, skip that, skip that. So the summary of this work is that split, at least for LA County, after this realignment in California, split sentencing is really the key to achieving substantial improvement in this trade-off. Next slide. That's not to say that split sentencing should be used in lieu of pretrial release. After all, pretrial release people aren't even guilty yet, and I agree with everything that's been said in this session about the problematic aspects of pretrial release and the bail trap. And next slide. And in my New York Times op-ed, as journalists, I'm sure you can relate to this. I sent in like a 900-word op-ed and included 400 words on the bail trap and giving a balanced decision that really you should be doing both split sentencing and bail trap, and they basically viewed the bail trap as yesterday's news, and took it out and published a rather one-sided thing, but at least got the main idea of this out. Okay, next slide. Next slide. So in California, there's Assembly Bill 1468 that was passed a few years ago. Unlike my Homeland Security work that directly impacted practice, I did my work after this bill, so I had no influence on this at all. But this bill required judges in California to give low-level felons a split sentence unless it was against the interest of justice. And so immediately over a few-month period, it went from virtually not using split sentencing at all to about 40% of the cases using it. They suspiciously have not released data in the last 3 years on this, and I've talked to a few people at Public Policy Institute of California who say that there's still some judges who are not working in the spirit of this law, but it is a movement in the right direction. So next slide. So the big picture here is this is the amount of incarceration in this country since 1880, and there was a big five-fold increase here, and it's starting to come down just a little bit, at least the initial part. I'm not sure if this is still true, but after the initial decline, over half of this was due to what's going on in California. And the big picture here is that there's three main ways to reduce incarceration. One is reducing the drug sentencing, another is pretrial release, and the third one is split sentencing. The first two get a lot of media attention, they get a lot of scholarly attention, and they both deserve it. Split sentencing kind of seems to be under the radar, and the main contribution of this paper is showing that from a purely operational point of view, it's worthy of serious consideration. Next slide. How am I doing for time? Okay. Next slide. Yeah, keep going. So stop right here. So I want to just spend a few minutes talking about somebody else's research that I read this paper. I encourage you to take a look at it. It's really fascinating. Paper came out last year in Criminology by Rice Hester. Next slide. So South Carolina is one of the very few places in the country where they have judge rotation. And this is particularly relevant to rural areas. So in South Carolina, except for the county that Charleston is in, the rest of the state, each county has a single judge. And what they did is institute judge rotation. So each judge stayed in their home county for 9 months of the year, and for the remaining quarter of the year, they rotated through the other counties a week at a time. And it turned out that, not surprisingly, the defense attorneys and the prosecutors both knew the judges' reputations. And judges were generally viewed as being lenient judges, harsh judges, or, as I'll explain in next slide, pragmatic judges. So what happened here is that defendants went judge shopping. They could see the schedule of who's coming up over the next few months, and defendants tried to avoid the harsh judges, and they waited in line to plea out before the lenient judges. The harsh judges, as a result, basically did all the few trials that, few things that went to trial. The harsh judges handled those. But then they were essentially shut down by Tuesday afternoon. They had nothing to do, and they just sat around all week. The pragmatic judges were ones who, when they were in their home county, they were pretty harsh. But they understood these dynamics. They didn't want to get shut down. So when they were on the road, they became more lenient in order to continue hearing cases. And the prosecutors, for their part, basically warned the defendants, say, either take a plea with this lenient judge, or I'm going to put you up to trial with this harsh judge. Next slide. So what were the outcomes? So 98% of the defendants plead, but the lenient judges set the standards. Next. So the mean sentences were reduced. The mean length of the jail sentences were reduced. And just as importantly, the variation in the jail sentences were reduced. So before that, if you were in a county that had a judge that was harsh on drugs and you happened to have a drug violation, you were stuck. If you were in a county where a judge had these implicit biases against black or certain genders or whatever, and you were one of those people, you were stuck. Now, you could shop around a little bit and get a reasonable deal. Next slide. So the author, Rice, has given me the data. We're working together on this, and I'm building a mathematical model essentially of the game, of the negotiation between the defendant and the prosecutor, where there's this judge rotation, and where we're trying to understand how much, the operational details, how much judge rotation do you need to get some, what I would view, good results like this? And how much transparency in the schedule do you need to get good results like this? And since so few states allow judge rotation, are there other operational approaches here? And I just happened to talk to a friend of mine who's a Supreme Court justice in California, and said that in California, the defendant is allowed to, you get two choices. You can, reject going to a particular judge, but then you have to take the second one. So if you can give just a little bit of flexibility and a little bit of freedom to the defendant, how much can you improve outcomes? Okay.
Thank you. Can we open this up for questions? That's fascinating. I have not.
Yeah, it's more interesting than my paper. It's really, it's really interesting.
I've never heard of a system like that rotates around like that, and it's easy to see that how you could game it. It's interesting to. It would be interesting to me to look down the road to see, in terms of the people who got the lenient, how their lives played out after that, and whether that was beneficial, or whether it was they got away with something.
Right.
Over here first. You're right. Kyle Oker from the Centerville, Iowa Daily Iowegian. Question for you in the middle. Do you have any data regarding the length of probation, when probation maybe isn't a good idea? I believe the Philly DA yesterday found after about 3 years, it didn't really do any good after 3 years. So do you have any data on that?
Well, I can just say, if you're talking about the split sentencing aspect, so the way, and I don't know why, but the way they do it is essentially a 50-50 split. So regardless of what the whole sentence would have been, they basically say the first half of that time you're in jail, the second half you're out. Most of these, again, are low level, so it's nonviolent, non-sexual, non-serious. That's the kind of definition. So most of these are less than 6 years, and so it would be less than 3 years on supervision.
Is it more expensive to be on supervision than on traditional?
No, than being incarcerated.
Well, it's definitely cheaper that way,
Yeah.
but by increasing split sentencing, does that add a financial burden that was not there?
So in California, what they did was take a lot of the money saved from incarceration and used it towards supervision services. The other big thing they did is that it used to be this was centrally done by the state, and now they shifted it out to the local people. So this person, say, was from Sacramento or something, and instead of it coming from a central place in California, California's a huge state, now they're having the local services where they feel like they can support the people better because they know the local job situation, they know the local community, and apparently that has been going pretty well.
Hi, I'm Danielle from the Leader Register in northwestern Wisconsin, and I just wanted to thank you all for sharing your information with us, and I appreciate it. I didn't mean to yell at you, Colin. I was just me trying to be vocal. There's a little confusion there. So I guess earlier I wanted to ask you, you said that things can be done.
Are you talking to him or me?
Yeah, Colin.
Yeah.
Sorry. You said that things can be done at the local level, and I am from one of the counties I cover has a population of 15,000 people. So it is rural America. So, I appreciate a lot of you are coming from New York City. That is not applicable to where I come from. We have one judge in Washburn County, and he's been the sitting judge for almost 30 years. So that's the situation going on where I'm from. And it's not like he's a bad judge, I don't think. He's just the judge and always has been for a long time. So can you speak to what can be done at the local level in rural America?
Yeah, sure. I mean, I think a big part of it is, especially in those places, a big part of it becomes judicial decisions that becomes decisions of sheriff offices that are DA decisions. So I think what's different is that a lot of the changes that we do see happen in those areas are less formal, right? It's not something that's state legislation or something like that. That it's something that a lot of it is, especially you think of an area of someone who's been a judge for a long time, that it's something they get routine in their habits and they sort of do things as they've been done. So in a lot of those areas, I think a lot of it is how do you educate and how do you get buy-in? One thing that we found for reform anywhere, whether it's in a large jurisdiction or a small jurisdiction, is that stakeholder buy-in is absolutely essential, right? Like, just no matter where it is, if a law gets passed that judges aren't interested in, judges are still going to find a way to get around it and continue with their practices. So we look at it. I mean, the closest one that I have is Mesa County, Colorado, which is also a small jurisdiction, and it's something that the real effort there came from the district attorney's office. That it was the district attorney's office that wanted to reform how practices were happening there and wanted to make it so that they weren't detaining low-risk people and kind of unrailing their lives and creating these problems. And they basically just had meetings with judges and public defenders there, and they worked together and hashed out new guidelines for how their pretrial system would work there. So it's not. I'm afraid that answer isn't too satisfactory because it's kind of just working it out amongst yourselves. But I think that's the primary way that it works, and maybe the help too that can come from the journalism angle, I think, would be a lot on the opportunity for education. That it's a big thing that judges see the people who keep coming back to them in court. They don't see the positive outcomes. Like when they release someone on recognizance and that person's case gets dismissed and they get to live a fruitful and happy life, they never know that. They never see that person again. They just see the person who they released on recognizance, and in their mind it was a mistake because that person got picked up for something else and is back in front of them. So they only get that feedback loop. And then they also, there's a concern that also judges become, and prosecutors too, can become too risk averse. That it's something that their concern is that what's going to happen is they're going to release someone on recognizance, that person is going to commit a crime, and that judge's photo is going to be on the front page of the newspaper because this person went out and did something, and now the judge is responsible. Where on the other hand, if they take a tactic where, like, similarly situated people, like say 15 people, you're concerned that one out of these 15 people might commit a crime, so then you lock up all of them pre-trial. Well, those 14 people end up being locked up unnecessarily. Their lives get derailed in these different ways, but it doesn't come out. It doesn't ever loop back to affect the judge. So I think that it's something that highlighting those stories and those impacts can be powerful. But it's in general, our impulse is just to go with that former story.
I actually think that you're kind of in a unique situation in that if you have the same person has been doing this for 3 decades. I know that most of Wisconsin is court records are online. You have and you're dealing with a relatively low number that you could do a fairly sophisticated analysis of maybe 10 years worth of data that you can get online to try to show what is the practice that's going on there. And we've heard a lot about how things seem to get done because that's the way we've always done it, particularly with judges. And the impetus needs to come from other places, sometimes from the defense, sometimes from the prosecution. But I think you have a potential there to take a look and get a snapshot of what this judge's practice is in a much more manageable way than you could in a situation where you'd have 10 judges over 20 years with one judge. Wow, that to me seems almost a golden opportunity.
Can I just add, especially if you can compare it to adjacent counties And that judge who's been there for 30 years behaves in a much different way. And there's been research recently in hospitals where, kind of related to something that you said, but reporting antibiotic distribution across various doctors. And just by reporting all the numbers, they found that the doctors who were oversubscribing started moving back towards the median.
Mitch Riles, I work for the weekly paper in Spokane. Colin, you said oftentimes over supervision can basically be setting people up for failure. So I'm wondering, is there like an optimal level of supervision depending on a person's situation?
In theory, yes. I think that it's something. I think that this is kind of a frontier for where a lot of this work is. I think there's been a lot of research in the probation context, and a lot more research in the probation context. In the pretrial context, there's an idea that there should be an optimal level, but I think the other thing that can complicate it is that as pretrial services is starting to get more funding, we're still learning about what it is that pretrial services can do and what different things are offered. So I don't think that there's a lot of research that finds what that optimal amount is, and at least my perspective in the meantime is a minimize harm perspective. That it's something there are things that pretrial services can do, and creative options too that can happen. There's there's a group called Silicon Valley Debug that's working in California, and they have in Santa Clara County, they just adopted a proposal that they're trying to bring out this fall that I think is, I think it is a pretty incredible model, and I'm excited to see if it catches on. It's called community-sponsored release. And what it happens here, and this is similar, they're adopting some things that have worked in the probation context. What happens here is that when someone is being conditionally released to pretrial services, it's not necessarily the government that's supervising and monitoring them and is potentially going to violate them and bring them back to be incarcerated. The person is able to opt and choose either a faith-based group or a community group or something like that then pledges to support this person pretrial and help to get them back on their feet and make sure that they show up to court dates, which interestingly enough is like originally what bail was, right? Like if we're going back to our English roots of bail, your surety is not necessarily someone who's putting up money or whatever else. It's not a commercial bail bond industry. It's a community, someone in the community who's helping that person get back on their feet and show up for trial. And that's kind of the model that they're looking at there, which on my end seems, it seems promising because it seems like something that can be tailored to an individual, that can be supportive and that can work and can, the hope is, I think, to, especially with people who have mental health issues, who have addiction problems, or even just people who are looking for jobs and aren't able to gain employment, that it's a kind of link that can do that potentially in a more effective way than just a generic pretrial services agency of the government.
Hi, my name is Eric Killey. I'm a freelancer out of New Mexico, and I wanted to ask Justine and Lawrence, based on the criminology, was it an article or a publication? I just want to know if I'm correct in thinking that it sounded like the prosecutors would say, "I'm going to take you to the harsher judge, if you don't kind of make a plea or a deal." And the 98% of, it looks nice up there, but it just reminded me of, fearing for the worst when you're copping a deal, or you want to plead out because you're scared of the future and what can come. So I'm trying to figure out, A, am I understanding that correctly, and B, if either of you or both of you can kind of touch on, is this a good thing? Because it kind of seems like the same situation to me.
You want to talk about it from the data perspective?
Yeah, I'll just, so this 98% is not out of the ordinary. So you might have better data, but I mean, every number I've seen is 95% at least people plea out. So that part of it is kind of business as usual. The part that's new is that as a result, everyone, by giving the defendant a little bit of flexibility, they're able to plea out to someone who's going to be favorable and humane and understands their situation and allows them to get a lower sentence. So is this the ideal justice system? No. Is it better than places that don't use judge rotation? I would say yes.
You know, put data aside, let's talk about sort of human nature and the role public defenders play, right? So I would have to advise my client, and constitutional right for a client to understand the risk of going to trial, the risk of what might be an enhanced sentence post-trial. Maurice talked about the trial tax. What that means is, you know, there is often a higher sentence, or judges will often say if there's a conviction, there's a higher sentence than if you plea now. And I can't tell you how many times I have had to say to a client, here's the deal, and have to say to a client, and should say to a client, here is the deal that's on the table now. We're about to go get sent out to this judge. And in New York City, unlike in, you know, smaller counties, there is a different judge. Now, we could talk about it's also a problem if it's the same judge, if you think about that, because that judge was the judge that would have given you a deal. Post-sentence, going to give you a harsher deal. If it's one judge, you don't have an option. So here you have to assess who are we getting sent to? And often I would say to somebody, this judge will max you out, and makes known of it. And those are the risks that people have to take. Now add pretrial detention to that mix, and you are upping the coercion, right? Often on lower level offenses, it's happening less and less because we started as public defenders to push against this, but a prosecutor would say, I'm going to give you a violation now, but it's a one-time offer, which means I'm going to offer you a deal where you'll plead not to a crime, not to a misdemeanor, but to a violation which isn't a crime. But if you don't take it today, I'm going to take it off the table for the future. And now the client, even if the client did not jump the turnstile, is going to probably take that violation and add to a rap sheet. It still goes down not as a crime, but it shows there was an arrest and a conviction for something less. That just simply because of the fear that if I go to trial, I'm going to get convicted of the crime. It is a calculus that every single person accused and being prosecuted has to go through at some point.
And part of that calculus, too, is do I want to spend the next year or 2 years, depending upon how long it takes to get to trial? And yes, I'm accumulating that time so that if I am convicted, it will be time served. Or do I just want to start now, get it over with, and do a lesser sentence and get it past me and go on? The question of do people who plead guilty to crimes that they didn't commit, the Registry of Exonerations, which if you just Google National Registry of Exonerations, you can find out how many of the 2,200 and almost 50 wrongful convictions people pled guilty. And that is just such a basement figure because most of the time when people plead guilty, there is no impetus to go back and undo it to prove because they're way past it. And it is exponentially harder to undo a guilty plea than a jury verdict. But it's something like 15% of the 2,000 that we know of pled guilty to crimes that they didn't commit or even crimes that weren't crimes in the first place, but it was a false accusation. So,
can I just point out kind of the root cause of this, just to put my operations hat on for a minute, is that the capacity of the judicial system is they're just overwhelmed, and it's set up that they simply cannot take to trial more than 5% of cases. The whole thing would grind to a halt, and that's partly why the prosecutors are forcing this, that one of the goals of this whole justice system is to keep things moving, and the way things have, whatever equilibrium we've hit now, the only way to do that is to have a very small portion of cases go to trial.
And one thing there for judges, too, it's a question for whether this excessive pretrial incarceration is a bug or a feature of the system. Because the thing is, when you incarcerate someone pretrial, you get their pleas a lot quicker. If someone's free, they're going to take as much time as possible, and they're going to build their defense. And if you start releasing more people, you're overloaded. So it's something that the coercion doesn't just come from the prosecutor end. The coercion comes from the judge end, because they're just trying to process cases. And you process cases more quickly when you put people in jail.
Larry Mays. I'm self-employed, which sounds better than unemployed. When Tina was talking, I was having a flashback that was not drug-induced. And I had to look up the book. Malcolm Feely wrote a book for Russell Sage Foundation in 1979 based on a study that he did. I'm trying to remember, I haven't scrolled down to see, but the name of the book is The Process is the Punishment, Handling Cases in a Lower Criminal Court. And, having read that book more than once, I'm struck by the fact that it's what he had to say in 1979 is as true today as it was then. For most of these folks, the process is the punishment. You run them through this, and low-level cases, misdemeanors, and minor felonies, you sort of deal, you mete out this punishment through the judicial process, and you don't even worry about jail or prison or whatever in terms of the notion of assembly line justice, which is also very, very critical in the system as well.
So true. So true. Right there.
Hi, Rose Schneider from the Altamont Enterprise. I had a question for Tina. You briefly mentioned, you were talking about basically the process of being detained and basically going for a disposition hearing, and you mentioned briefly, and I was wondering if you could elaborate on this, how in upstate for decades people were being detained and getting a disposition without an attorney, and I was wondering if you could expand on that, and if that's changed, if it's gotten any better at all.
So it was not that they would get a disposition. So they would, although there are jurisdictions throughout this country where on a misdemeanor you actually don't get the right to an attorney, and so it's just you're taking pleas in front of a judge with a prosecutor, or sometimes brought to a prosecutor's office and offered a deal to plead guilty without even being in front of a judge. Talk about sort of due process violations there, but on misdemeanors there isn't that automatic right in many places. So research that. But in upstate New York, it was the decision of bail. So as soon as you're arrested, you're brought someplace so that someone can decide whether bail you're going to be in pretrial or out pretrial. You would not have, for many decades in many counties upstate, even though in New York City for decades you did have a lawyer and you were brought to court, there you weren't. So it has changed, and it's changing is what I should say. There's the Justice Equality Act was signed. There was a lawsuit, Harrell Herring, that gave rise to 5 counties sued on behalf of sort of high caseloads, but also the failure to have resources to provide what's called counsel at first appearance. And then the governor has funded one of these initiatives for upstate. So some of the counties, Chattahoochee, it was a county where they didn't have this. Their statistics on pre-trial detention, so bail on misdemeanors, was in the 60%.
Since counsel at first appearance, they're beginning to report that those are dropping now closer to 50 and below. So there's a show. There will be a data set after, I think, what could be a solid data set to look in terms of upstate counties that didn't have this, the role of having an attorney present and how critical it is. So, I think time is getting, I want to sort of respond also about what you can do locally. And by locally, I mean all of you and the people who read or hear you, right, if you do public radio. We've used a lot of language that I think, and do use a lot of language as a shorthand in the way in which we report or talk about this work. We do it in our motion practice. We've done it on this panel. Defendant, felon, convict, prisoner, inmate, right? Those are words we use to define people. Particularly in small jurisdictions where people are reading and they're your jury pools and your judges and your prosecutors and the people who are actually affected by the system are reading or listening to the way in which you describe people who are in the criminal justice system. And that matters because it's beginning to sort of redefine and humanize the people we're talking about. A lot of this has happened not in the last decade, but centuries because of racist structural issues where people were not seen as people and categorized that way, and systems then were created to continue that structural racism, oppression, and marginalization. The more we begin, and I've sort of talked about this with lots of journalists and journalism schools, is I know it takes longer for us to say people who are incarcerated than inmate, but isn't it a better way to go? So one of the roles, critical roles you all play is, first and foremost, talk about those, you gotta talk about race. You got to talk about racism. You have to talk about the structural systems by which this came. And when you do, start using terms that aren't shorthand for what is an easy or maybe even might be a sexier title, like, if you said ex-con, but maybe you want to just say person who is released from prison. Because it sets the implicit bias gets undone a little bit when we start to spend time not in shorthand, but in sort of talking about people. And then it affects the judge who might be on the bench for 30 years, who might have only ever used the word defendant. And one day, the judge may stop and say, person accused. So just a tip.
One of my favorite headlines, every year the Registry of Exonerations issues an annual report on the number of exonerations and in the previous year and sort of what it might say or not say about the criminal justice system. And one year in reporting on this, Reuters had a headline that said something like, record number of convicts released. These are people who were exonerated. Still going to call him a convict. We can go a little bit longer. We have a question here.
Yeah, hi, Paul from the Keene Sentinel, Keene, New Hampshire. I was wondering, with debates over reforming cash bail or getting rid of cash bail, we've heard a lot of kind of data research arguments that really seem to support that idea. I was wondering if there are any arguments on the other side that, even if you don't believe, you give enough weight to, that you have to kind of engage with. So, like, what are the strongest arguments on the other side, and how do you engage with those?
So these are like the proponents of the money bail system?
Yeah, I guess so.
You're taking away my livelihood.
Terrible things happen, right?
Yeah, I mean, I think, well, all right, so you specifically wanted me to bring up like the arguments that I think have weight, right? The ones that are hard to address, because they do bring up a whole lot of things that are sort of paper tiger sort of arguments. I think the biggest weight, I think, for an argument for money bail is the one that Tina alluded to earlier, is this idea that when, and the phrase that always gets used is skin in the game, right? That it's something that when someone who's accused of a crime or their family member has to put money up, that's their incentive to return to court, right? That's the thing that makes them return to court. What has been set up here is that, we've seen that's not actually the case, right? That there are jurisdictions, and the kind of two big ones to look at are probably Washington, D.C., and now New Jersey, that recently instituted reforms this past year, that they've basically eliminated the use of money bail altogether. That New Jersey, it's still in the books, but 44 people had money bail in all of 2017 in the whole state. And what they found is that they have incredibly high appearance rates, that it's something that they have some of the best appearance rates in the country. So I think that's to me, that's the traditional argument for bail, that's the traditional reason for it, and I don't think that it holds up. The other arguments that might come out is bail being related to public safety or something like that. I think that it's pretty quick to disentangle that, because in most jurisdictions you don't forfeit bail for committing a new crime, you only forfeit bail for not showing up to court. And it's also something that if you're using bail bondsmen, that money's gone forever anyways, right? That's the other skin in the game argument, is the skin in the game thing kind of falls apart completely when you start dealing with the for-profit bail industry, because that person doesn't have skin in the game. They've lost this money no matter what, whether they show up for court or whether they don't show up for court, it's gone for them.
Years ago in Cook County, there was a practice where lawyers would troll the hallways of courthouses looking for people who were released on cash bond, and they would represent them for their cash bond. At the end of and they would almost invariably plead them out, and at the end there was a motion, CBR, cash bond refund, to attorney. And so the clerk would sign an order saying that their cash bond that was posted would go to the attorney, and that was the fee. And it led to enormous abuses, and there was some collusion between certain judges and certain lawyers who were kicking back part of their cash bond refunds to the judges, who would get them to the front of the line and give them relatively sweet deals. There's all kinds of impetus for, I think, wrongdoing in the cash bail system.
And also, if you want to talk to someone who it's like her personal hobby and a lot of fun to take on these bail arguments, talk to Charisse at lunch. She pretty much, she goes on radio and debates with people from the American Bail Coalition and everything, and she's got, she's got pretty much for every single argument that they have, she has good counterpoints for.
They're very, very available, and you want to talk to them, you can call them. Just Google them, and they're all the Bail Association.
What have they said in previous conferences?
Pretty much that. They say, the system has worked for us, it's worked for the United States. Their argument has always been that they're there for public safety, that if you want to ensure that the right people stay inside and the wrong people don't, we're your guarantor, we're your basic insurers. They avoid the whole question of the fact they're getting a profit out of this altogether, but they make a pretty strong argument, and and as the years have gone by, they become more and more vehement about in their defense for obvious reasons. They mainly feel they're on the losing side now.
Hi. Hello. There we go. Hi, Matt Hopp. I'm with the Herald Whig in Quincy, Illinois. Illinois recently enacted a new, basically, bond reform where everyone automatically gets an attorney now when they go before bond court, as well as they basically divided offenses into two categories, where one side of the defense or one side of the offenses, everyone gets about a $30 per day credit towards their bond if they're not posting. Are you aware of any other states that have done that type of process and how effective that kind of program is in actually getting people out of jail?
I think Kentucky does the reduction after a certain point. If you're in, your bond begins to reduce over time, and they don't have money. They didn't have I think they didn't have a system like that a number of years ago, but made that change.
Yeah, I mean, my question on it would be, what purpose? Like, what's the goal for something like that, right? That it's something that we weren't comfortable with you being released until you spent, this much time and that's sort of, I don't know. It's also something we were comfortable with you being released if you could afford it, but if you can't afford it, we're only comfortable off of this rubric of days that add up to money. I think it's something, it gets into this kind of this weird pathology of money bail that oftentimes you'll see for different places, like that the amount of your money bail has like a pretty much a linear correlation with whatever your charge is, that it goes up, and that's how much money you have to spend, which isn't, it's just, in some ways there's a logic to it that makes sense. Oh, it's like a higher charge, so it's a higher amount of money. But the question is always like, so what's your purpose? What was the purpose behind that? And if you were to break it down, the purpose behind that would seem that the goal would be for wealthy people to spend less time in jail and for less wealthy people to spend more time in jail, rather than kind of the goals towards public safety or court appearance.
I hate to have to call this to an end because this has been a great session. Join me in thanking our panelists, and you have their contact information. I'm sure they'll be happy to talk to you later or via email.